Hello everyone, welcome to the channel. Now we have reached to Article 19, which states that protection of certain rights regarding freedom of speech, etc. And Article 19.1 that all states, all citizens shall have the right A. To freedom of speech and expression, B. To assemble peacefully and without arms, C. To form associations or unions, D. To move freely throughout the territory of India, E. To reside and settle in any part of the territory, and F has been omitted. G. To practice any profession or to carry on any occupation, trade, or business. Subsection 2. Nothing in the subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercises of the right conferred by the said subclause in the interest of the sovereignty and integrity of the India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or incitement to an offense. Third, subsection, nothing in the subclause B of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing in interests of the sovereignty and integrity of India or public order reasonable restrictions on the exercise of the right conferred by the said subclause. Fourth, nothing in this subclause shall subclause C of the said clause shall affect the operation of any existing law insofar as it imposes or prevents the state from making any law imposing in the interest of the sovereignty and integrity of India or public order or morality reasonable restrictions on the exercise of the right conferred by the said subclause. Fifth, nothing in the subclause D and E of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing reasonable restrictions on the exercise of any of the rights conferred by the said subclauses either in the interests of the general public or for the protection of the interests of any scheduled tribe. Sixth, nothing in this subclause G of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing in the interests of the general public reasonable restrictions on the exercise of the right conferred by the said subclause, and in particular nothing in the said subclause shall affect the operation of any existing law insofar as it relates to or prevent the state from making any law relating to I. Number one, the professional or technical qualification necessary for practicing any profession or carrying on any occupation, trade, or business. Or second, the carrying on by the state or by a corporation owned and controlled by the state of any trade, business, industry, or service, whether to the exclusion complete or partial of citizens or otherwise. So now we can see that principles embodied in the Article 19 are that Article 19 confers six fundamental rights in the nature of freedoms to the citizens, and each of such right has exceptions to it provided in Article 19 2 to 6. And, and these six rights are as enumerated in Article 19.1. You can see them here, which are right to freedom of speech and expression, right to freedom of speech and expression, right to assemble peaceably and without arms, right to form associations or unions or cooperative societies, right to move freely throughout the territory of India, right to reside and settle in any part of the territory of India, right to practice any profession or to carry on any occupation, trade, or business. And in the original constitution, there were seven rights. One of them, Article 19(1)(f), namely the right to acquire, hold, and dispose of property, has been omitted by the Constitution by the 44th Amendment Act 1979. No right is absolute, and every right has a corresponding duty. And in respect of the rights enshrined in Article 19(1), certain limitations have been imposed by Article 19(2) to Article 19(6). However, these restrictions for the purposes mentioned in Clause 2 to 6 of Article 19, and these restrictions must be reasonable restrictions. Such restrictions can only be imposed by law and not by executive or departmental instructions. Also, it is the court and not the legislature which can judge whether a restriction is reasonable or not. It is the court and not the legislature which can judge whether a restriction is reasonable or not. Number one, the freedom of speech and expression, the first right. Freedom of speech and expression means the right of to express one's own convictions and opinions freely by words of mouth, writing, printing, pictures, or any other mode. Freedom of speech is regarded as the first condition of liberty. It is also said to be the mother of all liberties. In freedom of speech and expression on internet in Shreya Shingal versus Union of India 2015, the Supreme Court held that the provision of Section 66A of the IT Act 2000 is derogative of the Article 19(1)A, and as such it is an arbitrary provision which breaches the rights of citizens to have freedom of speech and expression of their views on internet. As such, the provision concerned is constitutionally invalid and was struck down in its entirety. Right to internet access in Anuradha Bhasin versus Union of India, AIR 2020, the Supreme Court, AIR 2020, in the year 2020, Supreme Court held that the right to freedom of speech and expression under Article 19(1)A and the right to carry on any trade or business under Article 19(1)G using the medium of internet is constitutionally protected. The court further observed that any curtailment of internet access has to be reasonable and within the boundaries laid down by Article 19(2), the clause 2 of the Constitution. Earlier, the Kerala High Court had held in the case of Fahima Shireen, RK versus the State of Kerala, AIA 2020, that the right to internet access is a fundamental right forming a party of the right to privacy and right to education under Article 21 of the Constitution. Furthermore, in the case of Foundation for Media Professionals versus the Union Territory of Jammu and Kashmir 2020, the Supreme Court of India ordered the constitution of a special committee to review the restriction of internet mobile service to 3G in the Union Territory of Jammu and Kashmir. The court recognized that the rights to freedom of speech and expression, health, education, business must be balanced against prevailing national security concerns. Now, freedom of press, and freedom of expression includes freedom of press. Freedom of press means right to disseminate ideas or news or views in various forms like newspapers, TV channels, making of film or documentary, or by writing an article. Free press has been described as fourth estate of democracy. It is supposed to guard the liberty of press, which ultimately protects public interest by questioning about misdeeds, lapses of the government, and other bodies exercising governmental power. In Ramesh Thapar versus State of Madras, AIA 1950, the Supreme Court had held that restriction on circulation of the newspaper inevitably leads to restriction on freedom of expression of press. The Supreme Court held that freedom of speech and expression includes freedom to propagate ideas, which is ensured by freedom of circulation of a publication, as publication is of little value without circulation. In this case, Patanjali Shastri Justice rightly observed that freedom of speech and of the press laid at the foundation of all democratic organizations. For without free political discussion, no public education so essential for the proper functioning of the process of popular government is possible. Furthermore, in the case of New Express newspaper, Private Limited versus Union of India, AI 1958, the validity of Working Journalist Act 1955 was challenged on the ground of violation of Article 19(1)A. The court held that this act is valid because through this act, the provision for improvement of services condition of workmen of the newspaper industry can be ensured, which is a reasonable restriction under Article 19(1)G of the Constitution. The act provided for number one, the minimum wages for all workers and journalists. Number two, declaration of Sunday and all other national holidays as compulsory holidays. Furthermore, in the case of Ajay Goswami versus Union of India, AIA 2007, the court recognized the right of adults to entertainment within acceptable level of decency on the ground that it may not be inappropriate for children. The court observed that nudity alone is not enough to make material legally obscene. The standard of judging obscenity should be that of an ordinary man of common sense and prudence, and not that of a hypersensitive man. Furthermore, the court in R. Rajagopal versus State of Tamil Nadu 1994, popularly known as the Auto Shankar case, held that the petitioner have right to publish an autobiography of Auto Shankar. Hero Auto Shankar was nickname of Indian serial killer Gauri Shankar, who was in death row. It was declared that once anybody's life history is in public domain, then it can be published without his consent, or authorization, and there is right to privacy is not infringed, and it becomes a legitimate subject matter of publication for press, media. But if publication goes beyond that and publish something which is not in public domain, then it can be a violation of right of privacy. But in interest of decency, under Article 19(2), the name of the female victims should not be published in the press in the matter of rape, sexual assault, kidnapping, etc. In Election Commission of India versus M.R. Vijaya Bhaskar, 2021, the Supreme Court held that the freedom of media to report the oral observations and discussions made by judges and lawyers during a court proceeding. It held that freedom of speech and expression under Article 19(1)(a) extends to reporting judicial proceeding as well. It observed that the concept of an open court requires that information relating to a court proceeding must be available in the public domain. Citizens have a right to know about what transpires in the course of judicial proceedings. And furthermore, the commercial advertisements were spoken about in Tata Press Limited versus MTNL 1995. The Supreme Court declared that the right to commercial speech or an advertisement is part of a fundamental right to freedom of speech and expression guaranteed under Article 19(1)(a). Earlier, in the case of Hamdard Dawakhana versus Union of India, AIR 1960, the Supreme Court had held that obnoxious and fraudulent advertising is not protected. Furthermore, pre-censorship and exhibitions of films were talked about in K.A. Abbas versus Union of India, AIR 1971. The court opined that under Article 19(2), the films have to be treated separately as compared to other forms of arts and expression, and it is valid and justified because a motion picture could affect the viewer's emotions more deeply than other art forms. Hence, after this case, films were classified as A and U categories, and then it was declared that films come under the purview of reasonable restrictions of Article 19(2), and the A and U here talked about the categories are adult and underage. In Bobby Art International versus Ompal Singh 1996, the Bandit Queen case, the petitioner filed a writ to quash the certificate of the exhibition given to the film Bandit Queen and restraining its exhibition. The contention of the respondents was that though the audiences were led to believe that the film depicted character of a former queen of ravines, Pulan Devi, the depiction was abhorrent, unconscionable, and slur on the womanhood of India. Especially the rape scene of the film, which was the center of the story, became cause of moral depravity of the Gujjar community. The Supreme Court upheld the tribunal order as valid with conditional certificate, which was embossed by the tribunal court, and said the scene where the actress has been stripped off and paraded naked is not to arouse the lust, but to raise sympathy in her for the victim and disgust for the perpetrators. It was finally declared by the court that the film must be judged in its entirety from the point of view of its overall impact, which carries the message of any social evil. Bans are illegal in the landmark judgment, Supreme Court CPIM, I guess, versus Bharat Kumar AIA 1998. It was declared that bans are illegal. The restrictions are reasonable and not to be widely opened. No fundamental right to go on strike. In Ramlila Maidan incident versus Home Secretary, Union of India, AI 2012, it was held that threat to go on hunger strike is also protected by Article 19(1)(a). The right to go on strike has not been held to be included within the scope and ambit of the freedom of speech and expression. In T.K. Rangarajan versus Government of Tamil Nadu, AI 2003, a division bench of the Supreme Court ruled that apart from the statutory rights, the government employees cannot claim that they can hold society to ransom by going on strike. As regards the lawyers, a constitutional bench of the apex court in Harish Uppal versus Union of India, year 2003, categorically pronounced that the lawyers have no right to go on strike or give a call for boycott, not even a token strike. The right to know in Maneka Gandhi versus Union of India, AI 1978, Justice Bhagwati emphasized on the significance of the freedom of speech and expression in the following words that democracy is based essentially on free debate and open discussions. For that is the only corrective of the government action in a democratic setup. If democracy means government of the people by the people, it is obvious that every citizen must be entitled to participate in the democratic process, and in order to enable him to intelligently exercise his rights of making a choice, free and general discussions of public matters is absolutely essential. Now, furthermore, the right to know about the assets and antecedents of a candidate before voting in People's Union for Civil Liberties versus Union of India, AI 2003, the Supreme Court reiterated the law laid down in Association for Democratic Reforms case. The Supreme Court ruled that the right of a voter to know the biodata and antecedents of a candidate is the foundation of democracy, a facet of the right to speech and expression guaranteed under Article 19(1)(a). Under Article 19(2) contains the main grounds on which the restriction on freedom of speech and expression can be imposed, which are stated as following. There are 8 grounds given. A. Sovereignty and integrity of the India. B. Security of the state. C. Friendly relations with foreign states. D. Public order. E. Decency of morality. F. Contempt of court. G. Defamation. H. Incitement of an offense. Furthermore, freedom of assembly. The second right, the freedom of assembly. Every citizen has the right to assemble peacefully and without arms. It includes right to hold public meetings and to take out processions. The assembly must be non-violent and must not cause any breach of public peace. This right, however, is not absolute but restrictive. Reasonable restrictions may be imposed under Article 19(3), subclause 3, in the interest of sovereignty and integrity of India or public order. It is nowadays widely known as the magistrate can put reasonable temporary restrictions on this right under Section 144 of CRPC to prevent imminent threat to public order or peace. See, the demonstrations expressing dissent have to be at designated places alone. Recently, in the case of Amita Sahani versus Commissioner of Police AIR 2020, popularly known as the Shaheen Bagh case, the Supreme Court held that Article 19 is one of the cornerstones of the Constitution of India and it confers upon its citizens two treasured rights, that is, the right to freedom of speech and expression under Article 19(1)(a) and right to assemble peacefully without arms under Article 19(1)(b). These rights in cohesion enable every citizen to assemble peacefully and protest against the city actions or inactions of the state. Supreme Court further observed that while appreciating the existence of the right to peaceful protests against a legislation, we have to make it clear that public ways and public spaces cannot be occupied in such a manner and that too indefinitely. Democracy and dissent go hand in hand, but then the demonstrations expressing dissent have to be at designated places alone. In Kanis Fatma versus Commissioner of Police 2021, the three judges bench upheld the decision of Amit Sahni versus Commissioner of Police, the Shaheen Bagh case, and further held that right to protest cannot be at any time and anywhere. Third, rights to freedom of forming associations. All citizens have the right to form associations or unions or cooperative societies. The right of association presupposes organizations. It thus includes rights to form companies, societies, partnership firms, trade union, and political parties. Reasonable restrictions can be imposed on this right on the grounds specially mentioned in Article 19(4), that is, sovereignty and integrity of India, public order, or morality. Right to form an association, union, or in All India Bank Employees Association versus the National Industrial Tribunal (AIA 1962). Court held that right to form associations or union does not carry within it the right to achieve any object. Thus, the trade unions have no guaranteed right to an effective bargaining or right to strike or right to declare a lockout. Secondly, in the case of Damayanti versus Union of India, year 1971, the Supreme Court stated that the right to form an association necessarily implies that persons forming the association also have the right to continue to be associated with only those whom they voluntarily admit in the association. Any law by which members were introduced in the voluntary association without any option of being given to the members of to keep them out, or any law which takes away the membership of those who have voluntarily joined it, will be a law violating the right to form association. In Delhi Police Non-Gazetted Karamchari Sangh versus the Union of India, 1987, the Supreme Court held that right to form association is a fundamental right, but recognition of such association is not a fundamental right. Fourth, the freedom of movement. Every citizen has a right to move freely throughout the territory of India. They can go wherever they like in Indian territory. They can move from one state to another and also from one place to another place within any state of India. In this way, it enshrines the principle that entire country is one unit so far as the citizens are concerned. The object is to create the sense of nationality in the minds of the citizens. This freedom cannot be curtailed by any law except within the limits of Article 19, subclause 5, that is, in the interests of general public or for the protection of interest of the scheduled tribes. The object is to protect the original tribes which are mostly settled in Assam, Meghalaya, Tripura, and Mizoram, sixth schedule. These are the states which are provided with security under the sixth schedule of our constitution. These tribes have their own culture, language, customs, and manners. So reasonable restrictions on right to movement are described in state of Uttar Pradesh versus Kaushalya, AI in 1964. The Supreme Court held that the right of movement of prostitutes may be restricted on the grounds of public health and in the interest of public morals. The right of a citizen to move freely may also be restricted in the interest of scheduled tribes. Number five, freedom of residence. Every citizen has the right to reside and settle in any part of the territory of the country. Right to reside means to stay at any place temporarily, and right to settle means to set up home permanently. The object of this right is to remove internal barriers within India or any of its parts. However, under Article 19, subclause 5, reasonable restrictions may be imposed on this freedom in the interest of general public. Article 19, subclause 5, which can be read as here. That Article 19, subclause 5, reasonable restrictions may be imposed on this freedom in the interest of general public or for the protection of the interest of any scheduled tribe. The right to reside, Article 19(1)(e), and the right to move freely throughout the country, Article 19(1)(d), are complementary and often go together. In Muhammad Salimullah versus Union of India, year 2021, the Supreme Court observed that the right not to be deported is an ancillary to the fundamental right to reside or settle in any part of India guaranteed under Article 19(1)(e) of the Constitution, which is available to Indian citizens. Sixth, freedom of profession, occupation, trade, or business. All citizens shall have the fundamental right to practice any profession or to carry on any occupation, trade, or business guaranteed under Article 19(1)(g). This right aims at the welfare and well-being of the citizens as well as the nation as a whole. However, there is no right to carry on business which is dangerous or immoral. The state under Article 19(6) may impose certain reasonable restrictions on this right, which are enumerated as follows: A. Reasonable restrictions in the interest of public. B. Prescribe professional and technical qualifications necessary for practicing any profession or carrying on any occupation, trade, or business. C. Enable the state to carry on any trade or business to the exclusion of citizens wholly or partially. Reasonable restrictions in the interest of general public. In Lakshmi Khansari versus State of Uttar Pradesh, AI in 1981, the Supreme Court held that a notification issued under sugarcane control order stopping crushers from producing Khansari for a short period so that the production of white sugar could be increased and thereby making the sugar available to customers at a reasonable price was held to be imposing reasonable restriction in the interest of public on the right of persons into using crushers and therefore was valid. In Bombay Hawkers versus Union of India versus Bombay Municipal Corporation AI in 1995, the Supreme Court held that the public in streets by their very definition meant for the use of general public and no person has the fundamental right to carry on any business which causes nuisance, annoyance, or inconvenience to public. It was therefore held that the provisions of BMC Act provided providing the power to the authority for granting or refusing licenses for hawkers on public streets and for removing unauthorized hawkers without giving them any opportunity of being heard were in nature of reasonable restrictions in the interest of general public and are not violative of Article 19(1)(g) of Constitution. Reasonable unreasonable restrictions in Chintaman Rao versus the state of Madhya Pradesh, AI in 1951, an act of Madhya Pradesh government empowered the deputy commissioner to prohibit the manufacture of beedis during agricultural season in such villages as he might specify in his order. The Supreme Court held that such a provision is void and it violates Article 19(1)(g), since the total population of the manufacturer imposes an unreasonable and excessive restriction on the lawful possession of manufacturing BDs. In Indian Hotel and Restaurant Association (AHAR) versus the State of Maharashtra AIA 2019, the bench said that there cannot be a complete prohibition from serving alcoholic beverages and in the bar as it violates Article 19(1)(g) of the Constitution. Furthermore, the right to trade off on pavement in Sodan Singh versus New Delhi Municipal Committee AIA 1989, it was held by the Supreme Court that right to trade on pavement is a fundamental right. Furthermore, right to property, the original constitution under Article 19(1)(f) guaranteed to every citizen the right to property. Secondly, Article 31, Clause 1 guaranteed that no person shall be deprived of his property save by the authority of law which the state could acquire for public purposes after the payment of an amount to the owner. And through a series of amendments to the constitution, this right was diluted, and finally, the 44th Amendment Act 1978 has eliminated the right to property altogether from the list of fundamental rights itself. Thus, Article 19(1)(f) has been repealed, and Article 31, Clause 1 has been taken out of Part 3, and a separate Article 300A was enacted, which reads, no person shall be deprived of his property save by authority of law. So now it has been clearly established that it is now a constitutional right and not a fundamental right, the right to property, which is given in 300A of our constitution, which was earlier a fundamental right.